Okay, everybody, we're going to take a break, but before we do, let's break down what's been happening right now in the courtroom under cross-examination of this witness. And joining me right now is a very special guest, criminal defense attorney and former federal prosecutor, Gene Rossi. Gene, great to have you back here on the program.
Oh, it's good to be back. Thank you.
So what's the defense attorney doing here? Is he trying to say that this investigation of the car, Heather Elvis's car, was not thorough, that there was cross-contamination? What is he trying to do? What kind of holes is he trying to poke into her testimony right now?
What he's trying to do is attack the chain of custody and the investigative methods, which I saw a lot. And hold on a second. I'm sorry.
That's a good. If that's your ringtone, I like it. Just so you know.
It could be a client. Could be a client. I just shut him off.
Don't worry about them.
No, but chain of custody is how did the police handle the evidence? How did they gather the evidence? How did they preserve the evidence? That's why he was asking questions about, did you wear gloves? What photos? It's not the strongest evidence, although in the OJ trial in the 90s, it had a lot of weight. The other thing is the defense attorney's trying to eliminate certain things. You found no keys. You found no phone. I have to be the professor here, the trial teacher. The defense attorney needs to be a little more organized. You need a paralegal to handle charts and exhibits. You should not be holding the exhibit binder with your witness. You want to be in control, and you want maybe the witness to go through the binder. He got a little disorganized there, but I'm just being picky.
So one of the things that this witness testified to earlier, and it was probably the most important piece, in my opinion, was that when she was analyzing and doing an investigation of Heather Elvis's apartment, she found a pregnancy test box in the trash, but no pregnancy test. So there is a question about where would that pregnancy test be? Where's the result? And what does that tell you about the overall motive and theme of the prosecution's case?
Well, I think the existence of the pregnancy test is evidence that she probably took the test. That they don't have the test, they could not find the test, that's of no moment to me. That they have the box suggests that Heather thought she may be pregnant. Obviously, that shows that she had a physical relationship with probably Sydney. But I don't think the absence of the test itself is significant. The box, to me, is the most significant for the prosecutor.
It could be, maybe. Here's a theory. We were talking about a little bit here that maybe she brought that test to Sydney on the night of her disappearance, if people believe that he had something to do with her disappearance, and maybe wanted to show him and maybe Tammy the results of that test. We're just speculating. We don't know. Theory to think about. We are going to take a quick break. Back here with Gene Rossi and the live feed in South Carolina. We'll be right back.
Okay, welcome back to the Law&Crime Network. My name is Bob Bianchi. I'll be here with you to 3 o'clock. Thank you to Jesse Weber for hanging out for an extra couple of minutes while I got ready. I got Gene Rossi with me. How you doing there, hashtag 40/41?
You're making my day. Hope you had a good weekend.
Yeah, a little rough getting into the city today. But anyway, listen, what do you make of this crime scene investigator, Gene? You've been listening to it from the beginning of the testimony. The defense seems to be trying to go somewhere. Where, based on your expert opinion as a former prosecutor and now as a criminal defense lawyer, do you think he's going with this?
Very simple. This is an extremely circumstantial case, and they are trying to actually build up the thoroughness of the search, I assume, of their home and the car. I couldn't hear everything, but they're trying to get the witness to say, we searched the 3 bedrooms, the kitchen, the bathroom. We found nothing inculpatory. We did a thorough search. And he's going through methodically where in the home or their car they searched and trying to establish there's nothing there, which suggests that they're innocent.
Right, so you have kind of like the reverse of what kind of happens in a circumstantial evidence case, Gene, and as you know, and our great audience and chatters in the chat room know, circumstantial evidence is where you're inferring facts that isn't directly, you're inferring 2 different things. So usually in a case like that, sometimes you find something like this where the defense attorney is actually saying to the cops, hey, you did a great job. You were very thorough, very professional, and that hurts the prosecutor because you really didn't come up with any direct evidence. Is that about right, Gene?
Absolutely. And last night I was watching a segment on the Robert Durst trial. the individual killed allegedly his wife and his second wife. And what they did is they did a search of his apartment in Texas, found, blood, incriminating evidence. They did a trash run, went in his garbage pail, found a receipt for a saw. You don't have that here against Sidney Moore and Tammy Moore.
Right, and actually, you actually led in, probably unknowingly, to a little teaser I'm going to do that we're going to have some amazing guests during my time hosting here on the Durst case. Don't go away, because it's really, truly a fascinating person that you'll be listening to. Gene, so far in the Moore case, what are you thinking is the best piece of evidence for the prosecution in terms of where they've gone so far in the case?
The best piece of evidence that I think is several. One, there's no cell phone activity that they could gather from Sidney's cell phone and Tammy Moore's cell phone in December. And then there's contact with the victim, Heather, on December 17th. The other bit of evidence is there's contact from a payphone to Heather's cell phone and vice versa on December 17th and the 18th. And that, to me, suggests that there was a plan, there was a scheme, there was a conspiracy. The problem is you still have to connect it to the Moores. And I don't know if they've done that sufficiently yet.
Okay, well, we will see. Gene Rossi, thank you very much for that excellent analysis. You were at the Law&Crime Network. We are going to go to a break, and we're going to come back on the other end. I'll be here at 3. We got a lot of good stuff coming up on the back burner, so stay tuned. Well, there you go. Now they're occupied doing various cleanup stuff there in the courtroom. So I got Gene Rossi with me, gives me more opportunity to talk to a real pro like Gene, who's actually trained over 1,000 prosecutors and has great experience both as a federal prosecutor, state prosecutor, as well as criminal defense attorney. So, Gene, do you think we were talking before about how this cross-examination is essentially saying in this circumstantial case, hey, you guys did all this great work and you found nothing directly linking my client. Do you think he's done an effective enough job and he'll back away, or will he continue to go a little bit more methodically, as you've indicated, with respect to this and kind of play it out?
They're going to embrace it. The absence of evidence points towards innocence. That is the strongest theme they could possibly have. And I listened to part of the opening by the defense attorney, and he had a good theme. They're trying to put a square peg in a round hole, and the absence of evidence supports that theme. And as someone who's done a lot of cases, you got to have a theme that fits the evidence, no pun intended, and they found a theme, and that is the absence of evidence points towards innocence. I think it's pretty good.
Yeah, absolutely. Well, they're back in court. Let's see what's going on now. Welcome back. Well, Gene, while she's taking that sip of water and a little downtime in that courtroom, you see the defense attorney, as you suggested would occur, is asking more questions. But, Gene, I know this rubs you the wrong way somehow. I know this. This idea of the pictures and mark for identification, I'm not sure who made the objection. It would be odd to me that either one would say the question, are these in evidence? Wouldn't both the judge and the defense lawyer and the prosecutors know what's in evidence and not?
Oh, Bob, I used to give a lot of lectures on exhibits, how to use them in trial, and this is actually killing me. What you do with a witness like this, you create a binder and you give it to the witness of admitted exhibits, and you stand at the podium or near the jury and you say, witness, would you go to exhibit 9 of the binder, please? Is that a fair and accurate photo of the kitchen? Yes. And then you just start asking questions. He's very disorganized, and I don't know if it's inexperience or just the pressure of the trial. He's losing me. He's losing me.
Gene, it seems to me that these pictures are if they're taken by crime scene investigators, should be pre-marked and attempted to be moved into evidence by, just consent of the parties, so you don't have to go through these machinations. And you can just show the witness the picture, and then the jury understands the context of what the witness is testifying to.
Bob, you know what I used to do, if I could, in all my trials, before the judge started the case in front of the jury, I say, Your Honor, the parties have agreed to the admission of the following exhibits. And I read it off, and it could be 150. And then the judge says, admitted. And then when I show a witness an exhibit, either by PowerPoint or a binder, I say, Mr. Witness, please go to admitted exhibit 38. You don't need any of this walking back and forth. It makes it smooth. They're putting the jury to sleep.
Yeah, I agree with you completely, Gene. Listen, we're going to have some great analysis of this case. It's fascinating, circumstantial case. It's got a lot of moving pieces, and so does a special teaser that I'm giving about a person who's going to be coming in and talking about a really, really high-profile national case. I can't wait to get to this witness. I keep saying it, and actually is a witness in the case. But we're going to go to break, and we'll come back on the other end with more Law and Crime. Well, somebody give me a glass of water. There's so much going on here, so much to talk about. I got Gene Rossi. He's waiting in the wings, 4041. I had a great interview there with Ellen on the Durst case, fascinating. And now my favorite, as you guys know, we're going to go to Top Crimes, and we'll come back on the other end. We are hot and moving today.
Here are today's top crime stories trending on Law&Crime.com and across the country. The former bassist of rock band Three Doors Down was sentenced to 10 years in prison in Mississippi for possession of a firearm by a felon. Todd Harrell, a founding member of the band, was arrested after authorities responding to a home alarm found drugs and guns in his home. Harrell served 2 years in prison for a fatal crash he caused in 2013 in Nashville and was kicked out of the band after a DUI offense in 2012. A Kentucky middle school teacher and nurse are coming under fire after video surfaced of them dragging an autistic student down a hallway, causing several abrasions to the boy. The child, Thatcher Grayson, is seen being dragged by his teacher and a nurse at the Tates Creek Middle School in Lexington. Grayson's mother has filed a complaint to the local district attorney. No criminal charges have been filed yet, but the nurse was placed on paid leave pending an investigation. Nicholas Cruz, the man accused of the mass shooting at the Marjorie Stoneman Douglas High School in Parkland, Florida in February, reportedly trespassed at the school 6 months before the shooting. Cruz allegedly confessed to the shooting during police interrogations and reportedly wants to plead guilty in exchange for life in prison, but prosecutors allegedly rejected the offer.
Just fucking kill me.
Cruz now faces 17 counts of first-degree murder and 17 counts of attempted murder. Those were today's top crime stories. I'm Anthony Velez for Law and Crime.
Okay, welcome back. So Gene Rossi, this guy Cruz, man, they showed a little picture of him putting the fake gun to his head, trespassed at this school previously. I had to do a lot of security at schools as the prosecutor. We were in charge of making sure we put security plans in place to protect students. What are your thoughts about this trespass piece? Is it going to be a problem for people down the road, either in a civil context or will it be used criminally? Was he casing the place out? What are your thoughts about this?
Well, because it was 6 months before the horrific incident, it's very hard to overly second guess the school officials and the police, because we don't know the circumstances of what happened 6 months before. Was he hanging around the gym? Was he stalking somebody? Was he being a nuisance? We don't have all the facts, but it was 6 months before. Now, if it was 6 days before or even 6 weeks before, then that would have been a big red flag and loud gong. But I'd have to have more facts.
There's so much controversy that I found as the prosecutor, Gene, with pushback actually from the schools when law enforcement would want to come in there and do interdiction and target hardening. And what we did was have whole schematics and plans prepared so that if we had to go to a critical incident, whether it was an active shooter or just a natural event, we would know where the emergency shuttles are, where the entries, where the exits. We try to tell them how not to do certain things so that people don't have immediate access to get onto your campus. Because I always said that I think our kids and our students are our #1 critical infrastructure target. And I found in my experience, I don't know if you have any similar experience, but
yes.
But I'm like, yikes, man, we're here to help you. We're not here to take over your schools.
Well, Bob, I got to brag a little bit. I have 3 kids, and they all have attended T.C. Williams High School in Alexander, Virginia. Remember the Titans? Mm-hmm. And it is 4,200 kids. It's the largest public school, grades 9 to 12 in Virginia. And it is a very safe school. I got to add that. However, they have a tremendous security plan in place in terms of where you exit for an emergency. What if there's an alarm? It's pretty darn impressive. And knock on wood, they have not had any incidents, a few scuffles here and there that you would expect with teenagers. But it's a very safe school, and you need a plan like that in place. I don't know what they had in at the Douglas High School, but that horrific day is something that is going to be with us a long time.
Right, Gene. We can't be overly critical on this trespass piece because we just don't know enough about it. But I will say this as a public service announcement: law enforcement needs to be involved in protection of the schools, and you need to create a culture of safety. I'm sorry if it's uncomfortable or disquieting to some people, but seconds make differences in events like this, and I see nothing wrong with it, and I think it saves lives. But Gene Rossi, we're in the Moore case, and we got to throw to that now, because we got some fascinating testimony, and the defense is doing some pretty good job at supporting the cops that are testifying and the crime scene investigators in order to prove their client didn't do it. A little twisty there, but it's effective. Let's go back to court. Okay, welcome back. So there we have Dennis Hart, a co-worker, both direct and cross-examination. Gene Rossi, what are we making of this testimony? And I just had to take a little, so every now and again we have to, a little humor and something, but I love that, do you consider somebody a good employee if they're having, sex? That, I don't know where that's really getting us or where he's going with that, but what are your thoughts? What's the defense doing?
Bob, we're simpatico. I got to tell you, why did he ask that question? I mean, really?
I don't know, but he asked it. I think, like you said from the previous witness, though, he's just trying to bring out that kind of like, in my opinion, the so what? So what is the value of this evidence?
I do want to say this. I think Dennis Hart is a fantastic witness for the government. It obviously gives them motive, but I'm picking a little bit on the prosecutor. I didn't really get when this conversation occurred between Dennis Hart and the defendant, Tammy Moore. I assume it's right before the alleged kidnapping, but she should have peeled the onion and got more details. How long was the conversation? What time of day? What day? I mean, was this eight weeks before the kidnapping, or was it 8 days? You got to bring that out. I don't think she did.
Right, yeah, the context is important. Now, Gene, not in all states, not all of this evidence is what victims are saying or victims are feeling or victims are in fear, or all this stuff is not necessarily always admissible evidence. Obviously, in this court, they're allowing that evidence, but do you see any problems with its introduction?
Yes, if I were the defense, that the victim was scared of Sydney and Tammy is prejudicial and shows that they're probably the two people, or at least one of them, took her life. So it came in, it was probably inadmissible, and it hurt the defendant.
Yeah, I mean, just so our viewers understand, that's because the defendant doesn't have an opportunity to cross-examine the statements or the fear that the victim had because they're not around. I know it sounds counterintuitive, but you got to be careful, Gene Rossi, because you know me and you feel the same way. You got to win it clean so it doesn't come back on appeal. Hey, guys, listen, we're going to be back with more Law and Crime after the break. We got a lot going on. Stay tuned and get in that chat room. If you have any questions, we'd love to answer them. What you saw there is the continued cross-examination in the Moore case of the crime scene investigator. Gene, just for our viewers who may be catching that clip because they're on break right now, that was previously recorded from earlier today, could you give us the idea that you mentioned before as to what you think and why the defense attorney is being so methodical going through all of the things that this crime scene investigator did?
Well, I think he's trying to bolster that they did a very thorough investigation of the parents' home, of her car, and they found nothing that would point towards Tammy or Sydney being involved, Tammy Moore being involved in the crime. So they're basically doing a direct examination of the government's crime scene investigator, Jill Dummengauer. And my only complaint is a little more precise, a little more efficient, a little more organized would have made your point a lot better. Hey, Bob, I did want to go back to something we said in a previous session. The feelings of the victim, Tammy, of Heather, may come out under Federal Rule of Evidence 804B6, which I'm sure South Carolina has an identical rule, and that is this. If a witness is unavailable and you have caused the absence of that witness, you can't use it as a sword and a shield. That victim's statements can be used against you if you allegedly caused the unavailability. So I think on appeal they got an argument. Yeah, it could come in.
It's dicey evidence. We have the similar corresponding rule, but we also have a case that interprets it very negatively for the prosecution because of the Fifth Amendment right to cross-examine. So it is a fine line. Guys, listen, we are going to go to a break and come back with more excellent analysis with Gene Rossi on the Moore case and other things that we got to pop in here at the Law and Crime Network. Stay tuned. And if you're not already in that chat room or you don't have the app, you need to do it. And please share with your family and friends because this is what keeps us all together at the Law and Crime Network to be able to do this gavel-to-gavel coverage. We'll be right back. Okay, welcome back. We're in the Moore case. Hey, Gene Rossi, I want to just pick up on the point because this is really nuanced stuff. It's great trial stuff. Not a lot of people can really talk to it. We were talking about this information. In Jersey, we call it Machado information after a case, but the introduction of a victim's statement of fear and then being used to introduce it in a murder case. And I think a point that we were talking offline on is very important, is that as a prosecutor, you got to kind of evaluate whether you really need it or not because you don't want to risk the appeal. But in a circumstantial case where there's no body and you have kind of a weak case, it may be a thing where as a prosecutor you say, you know what, I'm going to push the line a little bit because it seems to me on appeal, and let me see if this is your experience, a lot of times they'll say, well, it was really important for the prosecutor to have as opposed to it was just overkill and cumulative evidence, and they're more partial to it if the prosecution really needs it. Thoughts?
Yes, very much so. Whenever I had a really strong case, I always had to avoid that hesitation to kill a fly with a bazooka, if you will. But when you have a circumstantial case, and like the case down in Jessica Chambers' case, you know, you're going to err on the side of pushing the edges of that evidentiary envelope because you know if you don't get that extra bit of evidence in, it could be an acquittal or a hung jury, and you're willing to risk a little bit of aggressive argument in order to get that conviction.
Yeah,
so
that also goes to Rule 404, which most states have. It's the federal rule. Most states have a corresponding rules. Other act evidence, which is typically inadmissible unless it goes to prove intent, motive, preparation, opportunity, plan, absence of mistake, things of that nature. But especially when motive, prosecutors use that 404 information for motive. I had a number of cases where the judge allowed a whole body of evidence, but the case was going in so good that I said, you know what, I'm hitting a fly with a sledgehammer, just like kind of a very similar analogy you use, and I backed off using all of it, maybe a piece or two to establish my motive, didn't use the rest that the court permitted, and literally on appeal, they said the prosecutor used restraint, and so they allowed the ones I did use to go in without reversing it.
Yeah, there's a famous case, you're aware of this, you probably did it on your show, the staircase murderer down in North Carolina, where he threw his wife down the stairs and she died.
Right.
About 20 years before that incident in Germany, the prosecution brought in 404 from an incident that occurred in Germany, and it wasn't proven, he wasn't charged or convicted, and they brought that in. And I think at the end of the day, the appellate court didn't like that it went in, and eventually it had a retrial, and I think he did an Alford plea to like 7 years or 12 years time served.
Yeah, listen, we're going to jump into court, Gene, but just to round the rest of this conversation out, because I don't think we get a lot of people that know a lot about Rule 404 and all these other exceptions. A lot of times there's cases that actually list what kind of 404 evidence you can use. How remote is it? And I think you went to that prong of remoteness. It's so far away that it wasn't inherently reliable, and a number of other factors before you admit that evidence that the rule itself says is disfavored evidence unless you can specifically use it and need it for the motive and opportunity, intent, plan, preparation, things of that nature.
Yep, absolutely. And that's why, Bob, as you know, this is getting in the weeds, you always should notice that up well before trial to give the judge a heads up and the opposing counsel a chance to oppose it.
Absolutely. Okay, listen, guys, we're in the Moore case. There's been some great testimony going on and some real tactical lawyering happening. Let's go back and listen. They're in recess right now. We will get back as soon as they're live. But let's listen to a previously recorded clip and come back on the other end and discuss it with my man, Gene Rossi. Okay, welcome back. I told you we are on fire here at the Law and Crime Network. We have an update for you. We did Durst. We're in the Moore case. But you guys know we've also been talking about this Ohio versus Robert Rembert case. This was originally a death penalty. It was dropped without explanation, Gene Rossi, by the prosecution. 1997 rape and strangling murder, victim Rita Mae Payne. 2015 charges for deaths of his cousin and a friend, charged with rape and strangling a girl, Kimberly Hall, a 1997 case, which was separated from this case. DNA based on another unrelated incident brought these cases together, and it matched the DNA of Rita Mae Payne. We were going, there you go, there's the hero of the day, Robert Rembert, serial murderer. Here is the update. During jury selection, or in the process of going to jury selection, he has just pled guilty, folks. That case is no longer going to be a trial. The serial killer there, truck driver on trial for one murder and associated with lots of other murders, Robert Rembert, who's a one-man crime machine, has pled guilty to what we are understanding right now, 5 murders. Now, our producers are all over this, and we're trying to find out the parameters of this plea agreement, but this is a major development. This guy was a one-man crime machine, horrible acts, brutality committed, and you know what? He folded like a cheap suit when he had to go to trial on this one. So this bad boy is, I'm sure, going to be going down for a long time. Gene Rossi, the prosecutor in me, is bubbling up. I love it when I see this because, you know, I'm not afraid to try you, Mr. Rembert, tough guy. I'm not afraid to try you, but you saw the whites of the eyes of the jury, and you folded like a cheap suit. Gene Rossi, good day for team prosecution.
Absolutely. I've had pleas that were consummated during and right after jury selection because of 2 things. The defendant, for some reason, thinks that the trial is not going to occur. There may be a continuance, or that the government's going to dismiss the case on the eve of the trial. But when they see that jury come into that courtroom, the pool, and they look at who's going to be their triers of fact, and they realize that maybe it's time for me to plead, and that's probably what happened to him. I would like to know is, I assume that they dropped the death penalty, because you shouldn't, you can't plead to a death penalty.
Yeah. Yeah, the penalty was off the table earlier. You know, though, I think a lot of it has to do with the fact that you have tenacious prosecution. Like, for example, I've been in counties as a defense lawyer where they'll plea bargain murder cases to manslaughter that are good murder cases. When I was prosecutor, I wouldn't plea bargain a murder case to anything other than murder. You want to plead to the indictment and take your chances with the judge, fine, but I'm not going to say it's something that it's not. You murder somebody, you're going to jail.
Right, right. And well, that I got to tell you though, Bob, you're kind of unusual, because many prosecutors will say, and there's nothing wrong with your position or theirs, that, you know what, I'll take a guilty plea to something less, but you always have to clear it with the family and relatives of the victim.
Yeah, well,
if they're on board to a lesser count, go for it.
Yeah, I would do that in a lot of cases, but not when it came to murder, rape, and violent crime like that. But I respect that opinion, Gene Rossi. We're on fire. I'm on fire. We're going to break. Be right back. Okay, welcome back. We got it all going on here in the Law and Crime Network. Gene Rossi, again, this case where he was trespassing before and wound up on the property, and a lot of people in our chat room lit up when we were talking about the need for law enforcement to work cooperatively with the education community to target hardened students. And one of our chatters, I apologize because I usually like to give their handle, but they made a reference to the fact that people are afraid to put metal detectors in schools and potentially have armed guards or train students as to what to do to either evacuate or hunker down. I noticed that when we went out there and were trying to explain to them what you should do in an active shooter scenario, and there was just so much bristling and pushback. You indicated a school that was doing a great job, but why do you think that is in the education community for those that start to push back on law enforcement teaching people how to be safe? Should we do that in this environment?
Yes, and I want to go back to Alexandria, T.C. Williams High School in Virginia. And the beauty of our city, I'm very proud of Alexandria. We have a phenomenal relationship between the police department, the sheriff's department, and the community and the schools. And what happens when you have those groups coming together, you get a collaboration and basically a unanimous agreement on how to keep the schools safe. And we don't have metal detectors. We do have hall monitors and procedures in place and security officers. But I'm very proud, knock on wood, we haven't had incidences, even though we have 4,200 kids in the high school. And we have a middle school with a lot of kids, grades 6, 7, and 8. And that's the key, having a collaboration among the police, the sheriff department, and the schools and the community. And Alexandria should be replicated in other parts of the country.
Yeah, you know, in my jurisdiction, I had 44 law enforcement agencies under my control, a whole plethora of schools ranging from multiple colleges all the way down to grammar schools. But it also goes to bullying and programs that we were also, don't get me wrong, some schools were very proactive, some districts very proactive out there. But there were times where it'd be crickets, for example, when we would be there with the top law enforcement echelon, top education echelon, trying to do something about bullying in a school where it was a problem. Nobody shows up. And then, of course, something happens, a kid commits suicide. And what's the first retort? How come law enforcement and the education community didn't do anything to help us when we were there all along? I found that dichotomy exists in a place different than what you're talking about.
But yeah, we're very, Bob, I got to say, we're very lucky, our jurisdiction. And, you know, I got to knock on wood. I'm very proud of it.
Excellent. Yeah, it should be a model that gets out there. And don't get me wrong, some schools do it beautifully, and there's a great symbiotic relationship with law enforcement, and it's always a positive. So, Gene, let's go back to this Tammy Moore case. Can you explain to the audience, as we've seen the clips of the testimony so far, what are the charges here? And then can you explain what a circumstantial evidence case is? And then I got a couple of questions for you after that.
Yeah. The charges, as I understand it, against Tammy Moore are, one, it's what they call a substantive count against her called kidnapping. Count 2 is a conspiracy to commit kidnapping. And what I do want to ask is, why is there only one defendant at that defense table? What happened to the kidnapping and conspiracy charge against Sydney? Did they dismiss it with prejudice? I know it was a hung jury. Why isn't he there? Now, to answer your question about circumstantial evidence, circumstantial cases are very hard because you can't just rely on records of a payphone. You can't just rely on cell tower records. We have no statements of either the husband or Tammy Moore, the wife. We have no notes. We have no diary entries of the defendants. We have absolutely nothing, and we're relying on just, data. And I got to tell you, I feel for the prosecutors. They have a tough row to hoe. And it's sort of similar to that case in Batesville, Mississippi, Jessica Chambers. Circumstantial cases are very, very hard because if you're a defense attorney, you can say, where's the beef?
Yeah, well, Gene, here's where I think their case gets the strongest. And it's powerful, even though a prosecutor doesn't need it. They've got a really powerful here where typically they don't, and it's motive. Okay, so he's stepping out, when I say he, Sydney Moore, the husband of Tammy Moore, who's on trial right now, there they are right now, husband and wife. He's stepping out on her with the victim, Heather Ellis, who's 20 years of age. And there is a possibility that when the relationship ends, that she's pregnant. And one of our great workers here, Kathy Russell at the Law&Crime Network, indicated that previously there's testimony that there's a pregnancy box that's recovered from her house, but no actual test itself. There she is. There's a substantial age difference in my mind, at least to a certain extent. Nevertheless, he is stepping out. She is now pregnant. So who's got all the motive in the world to be completely agitated, angry, mad, jealousy? It goes back to the days of the caveman. When they had caveman court, they were convicting people of jealousy murders. And then, of course, he's got to worry about the fact that he got her pregnant, and maybe she doesn't want to give up the child if it's pregnant. So now he's got a motive, if he didn't already have a motive, to do what his wife tells him to do. And here's my last point. It's the absence of evidence pointing to anyone else. That's where I think I would be going as a prosecutor.
Absolutely. You're right. The motive is, but that's motive. It's really not the circumstances. Circumstantial evidence is, your cell phone is 100 yards from where the body was found on the day of the murder. motive is sort of explaining. It's not really an element of the crime, as you know. But I got to tell you this. If I were the defense, I would bring out, if they haven't already done this, that Mr. Sidney Moore was, a ladies' man, went out with a lot of women. Tammy Moore knew of that, and they had an open marriage. And give the jury the impression is, hey, they weren't a model couple, but him having an affair with Heather, whoop-de-doo, he had him with many other people. That's what I would argue. It's unseemly, but you have to argue that. And I just thought of this. The defense attorney was trying to bring out that Heather had more than one physical relationship. She had, did something at work and gave the impression that there was somebody else out there that possibly was jealous of her relationship with other men. So that's something else that could be brought out if it hasn't already been brought out.
And let me ask you, though, one last question. Was there not some sort of expert testimony in this case with respect to a woman who had captured under surveillance a vehicle moving back and forth in a headlight analysis and kind of coming up with the make and model of a vehicle that was similar to Tammy's?
Well, you're absolutely right, and that goes to circumstantial, but it wasn't, it was similar to that video in the Quentin Tellis case where they had this truck coming out of a driveway. How clear was that truck? Was it the same color? Was it the same make? I don't get the impression they were able to identify the truck, other than it was dark.
Yeah, I think well, let me ask you, Gene. I mean, I've been around, tried a lot of cases. You tried a lot of cases. I've never heard yet in my life of a headlight analysis expert, but we could talk about that on the other end. You know why, Gene? Because I'm told court is live. Let's go back in. Welcome back, Gene Rossi. First of all, the prosecutor asking a question to this lieutenant, so I assume a retired officer, was an officer in New York, seems very knowledgeable, very skilled, was doing really good until we kind of get to the end there. He's taking pictures. He's not taking pictures of the camera that's in the house. I get that. He doesn't want to alert attention. But then no processing of the scene or going in there or even asking for consent till February. I mean, and the crime scenes are compromised. What's going on, Gene?
You know what? I'm missing something. I really must be missing something. Why they didn't go to a magistrate judge and present a search warrant on December 20th or the 19th is beyond me. And they went there. They were, I don't know how many police officers were there, but they're saying we didn't want to give them the impression that we're looking for information in your home. You got about 3 or 4 officers taking photos, yet they didn't get a search warrant until February. I don't get it. But here's the other thing. If I'm cross-examining Lieutenant Peter Sestair, I'm going to say this. The reason, sir, you did not get a search warrant on December 20th is you didn't even have probable cause to get a search warrant, and that's why you didn't get a search warrant. And number 2, they did not show any sign to you, body language-wise, that they had anything to hide, and they were very cooperative. I would just milk that. And then that they got a search warrant 2 months later just shows that they don't have their act together. My goodness.
Yeah, Gene, it'd be interesting. That theory, I think, works really good depending on how much knowledge they had. Obviously, they had enough knowledge to be there, like you said, to be taking photographs. And like you said, so our audience understands this, as a defense lawyer, you're saying you had all the data that you could have wanted. There was nothing really new in February. The only thing that was new was that you couldn't find a suspect. And so you figured you'd fall back on the people that you never thought were really that involved in it in the first place because you had, in the absence of having anyone else.
And Bob, that goes, theme is the best thing here. It goes back to their opening, the defense. Square peg in a round hole. They were trying to put a square peg in a round hole by saying they didn't have enough to get a search warrant December 20th. They got one in February. They were trying to put that square peg in a round hole. If the glove doesn't fit, you must have quit.
I was going to use that before, my man. Now you took it from me. I love you, Gene Rossi.
I gotta go.
Hashtag 40/41. I know you have to go, Gene. I always love when you're on my show. Come back soon, my friend, because you are the best.
You are the best. I'll see you later.
Okay, let's go to break. We'll be right back.